Curious about a case that could wreck your workplace? Lucky for you, we have a lawyer on the clock.
So, Phil, we've talked a lot on our program in recent months about the Fair Labor Standards Act and exemptions under the Act when we were talking especially about the salary threshold being raised under the Biden administration, which, of course, has now been overturned by the courts. But we did get into some discussions about the exemptions under the Fair Labor Standards Act. Just yesterday, the U.S. Supreme Court, in a rare unanimous decision these days, in a decision authored by Brett Kavanaugh, the court said that cases analyzed under the Fair Labor Standards Act relating to exemptions do not get reviewed by the courts under a heightened evidentiary standard known as clear and convincing evidence. Instead, the lower preponderance of the evidence standard applies. And so what that means is that preponderance of the evidence really is just, it's more likely true than not true. And so clear and convincing is something greater than that. Clear and convincing is a heightened evidentiary standard used by the court system, and it creates a higher burden for an employer to establish that somebody is either exempt or non-exempt in cases. And so
that's a big decision, and for it to be unanimous.
Yeah, exactly. And so Kavanaugh said that the Supreme Court only deviates from the preponderance of the evidence standard in civil cases in only 3 scenarios. The first is when a statute has it specifically written in there. The second is when the Constitution requires it. And the third is under Supreme Court precedent, in which the government pursues drastic action against a person, such as taking away citizenship. And none of those scenarios presented itself here. And so the court is going to continue to review these cases under a preponderance of the evidence standard.
Okay. Yeah. Interesting. Very good one. All right.
Yeah. So interestingly, this case, though, just by way of background, the case was brought all the way back in 2017 by 3 sales representatives. And the district court judge there in Maryland found in 2021 that they did not qualify for the exemption and were entitled to overtime because they spent more than half of their time at chain stores where they stocked shelves and placed orders, but rarely made their own sales. And so this case that started back in 2017 is now finally in 2025 just resolved based on this evidentiary standard. So pretty interesting. These cases take a long time. I've talked before when we talked about the Chevron case, and I said I think we're in for 5 to 10 years of bumpy roads here under Looper Bright in getting rid of Chevron deference for the cases to work their way through the court system. And this just shows you how long some of these court cases take.
Yeah, that is a long time. I mean,
it is
7, 8 years probably
Yes.
for that to come through. Absolutely.
Exactly. All right. So the next one I want to talk about, Phil, is 2 days ago, the U.S. Department of Labor issued an opinion letter on FMLA. They don't issue these very often in recent years, but they did issue one just a couple days ago dealing with the substitution of paid sick leave under state law and running concurrently with leave under FMLA. And so this is one we've been kind of waiting for guidance from the Department of Labor.
So yeah, we got this going on right now in the state of Missouri, Illinois, many of our other states that we're serving. So we're listening carefully here in this guidance.
Yeah, and so what the FMLA's opinion letter said is that if the employee is entitled to leave under a state paid sick leave law, the employer may not require simultaneous exhaustion or substitution of the paid sick leave provided by the state. So it's not entirely dissimilar to a situation where an employee is entitled to receive income replacement under a state workers' compensation plan or a short-term disability plan, we cannot require them to use that paid time, or not really the time. We can't require them to use the income replacement that those plans provide, but we can still require them to take FMLA time. This one to me is a little bit different because it's saying we can't require them to substitute their FMLA leave with this paid sick leave under state law. So we're going to have to see how this one kind of is interpreted by the courts when it works its way in there. I need to do a little bit more analysis on this, because the way it looks to me is that somebody could get their sick time under the state law and then get their FMLA time. So I want to look at this to make sure that the opinion letter really does say that people can, in effect, stack their leaves. But just be aware that this is out there.
So many of our listeners are listening for this word, run concurrently.
Yep.
And I think what I'm hearing you say is the guidance letter says they do not have the right to run concurrently. They would be separated.
Yeah, that's what I believe that this says. Like I said, it came out a couple days ago, and I want to go through this in more detail, but I just want to bring it to people's attention that if you're having an issue like this right now, we do need to take this into account.
Yeah, no, I think this would be really good to bring back up in the next week or two, Bert, because if that's the case, I know many of our employers have programs that do allow these to run concurrently within their policy in the way that they administer their leave absence management. And this would require some policy written changes, handbook notices, those types of things that may have already taken one path that need to now be reversed and taken in a different way.
Yeah, and just pulling a quote out of the opinion letter itself, it says, quote, "Because the substitution provision does not apply, neither the employee nor the employer may use the FMLA substitution provision to unilaterally require the concurrent use of employer-provided paid leave during the portion of the leave that is compensated by the state or local program." So that's state leave. And so I want to do a little bit more digging on this one, but I do want to bring it to everyone's attention.
Even though, and here's where it's going to get tricky, and you don't even have to comment on this, but I can foresee where state leave says it can run concurrently, but the federal law, which will supersede any state law, in that case, I'm assuming, will say it doesn't run concurrently, right? Because there are some state leave programs that allow it to run concurrently with FMLA. And then in this case, the now FMLA guidance is it does not run concurrently. We'll find out more. Stay tuned. Come back and listen to future episodes. We'll keep you up to date.
Absolutely. All right. One more for you, Phil. Just want to mention that anybody who's been watching any of the news channels the last few days, maybe you've seen some clips of the fiery confirmation hearings going on with Trump's cabinet picks. They've been interesting. It's a lot of political theater, in my opinion, because the representatives ask these questions that they know they're not going to get answers to. They ask these gotcha questions, and they cut the nominee off, and the nominees have been pretty aggressive in their responses. One nominee that has not yet had her confirmation hearing is Trump's pick for the Secretary of the Department of Labor. She's a Republican out of Oregon, Lori Chavez-DeRemer. She was or currently is a freshman member of the House. She just lost her reelection for that House seat. And so then Trump nominated her to become the Secretary of Labor. And this is one pick that I think the Democrats really, really like by Trump. And I think this is one that signals Trump's willingness to work with the unions moving forward. I don't think his administration is going to be anti-union. I've said on the program a few times, I don't think he's necessarily going to make it easier for employees to unionize, but I don't think he's going to make it harder for incumbent unions to stay in where they are especially in the construction industry. Now, again, she's been nominated for the Secretary of Labor. That's different than the National Labor Relations Board. But I just think that this pick is really interesting. I think the unions like it, and I think the Democrats like it. So just keep your eye on this one. I think she'll sail through pretty easily.
All right. Well, I can tell you it has been great political theater so far. I get tired of listening to it after a while because it's all out of the same stuff. But sometimes it's a little embarrassing, just as your everyday citizen watching this. I'm like, come on, these are our top politicians' behavior. It's just ridiculous.
I agree with you on that one, Phil. I watch it and I think to myself, I cannot believe we as citizens are paying spending our tax dollars on this. It's pointless. I understand everybody's, they need to do their duties and everything, but it is just pointless, and what a waste of money.
Yeah, and the whole gotcha effort that seems to be the catchphrase right now for these hearings it's just so silly. But let's move on and talk about something more productive.
Thanks for being an on-demand viewer of This Week at Work. Don't forget, you can be part of the show by watching live at 7:30 a.m. Central every Thursday morning, when you can get your burning questions answered by using the question mark icon to the right of the player. In fact, you can ask a question now. Head over to aimea.org. Under Member Resources, you'll find This Week at Work. Click Listen Live to register for our next episode and submit a question. Or follow or subscribe wherever you get your news and entertainment. We'll see you next week when we discuss what's happening this week at work.